Our speaker today is Elizabeth F. Jennings. Elizabeth is an attorney at Northwest Elder Law Group. She received a bachelor's degree, magna cum laude, from Clemson University and her law degree from Boston College. Prior to joining Northwest Elder Law Group, Elizabeth practiced elder law, family law, and civil litigation at an Edmonds, Washington law firm. Elizabeth's practice areas include real estate planning, estate planning, probate, and guardianship.
Okay, are you ready for me?
We are ready for you.
Let's see. Okay, so I am Elizabeth Jennings, as I was introduced, and I have been doing elder law for about 9 years, and so there's a lot that comes into it, particularly with estate planning and thinking through the decisions you make now that can affect how your estate passes or how decisions are made in the future. So we are just going to kind of touch the surface today. But if you've done estate planning in the past, hopefully this can serve as kind of a check-in, a checklist to make sure that you're on track, that the documents you've done before are still good and still accurately reflect your wishes. If you haven't done estate planning before, this will hopefully give you some things to think about as you make decisions, whether it's putting new documents in place or having conversations with loved ones. So these slides will be available afterwards, and I'm going to just kind of touch on a lot of big topics, but feel free to submit your questions along the way in the chat, and I will try to answer them as best I can in the time that we have allotted. So when I talk about estate planning, I think about 3 different categories. Probably the most common that people think about is planning for death, right? What happens when you pass away? What happens to your estate or your assets? How do you provide for your loved ones? But another big aspect of estate planning is planning for periods of incapacity. So if you're alive but unable to manage your own affairs, make your own decisions, have you put a plan in place where trusted individuals can step in and help you when you're unable to help yourself? And then maybe the more positive aspect of estate planning is planning to live a long time. How do we financially plan to age, provide for our care, and kind of transitions that we go through in our life? So I'm going to talk about these 3 big categories and some of the most common estate planning documents that you may want to have in your kind of box to pull out if needed down the road. So the perfect thing to talk about early in the morning is planning for death, which is probably one of those reasons why people put off looking at their estate planning, making some of these decisions. It's not necessarily the most pleasant thing to think about. But I like to think about planning for death as far as how are you going to provide for the people, the charities, kind of the people that matter to you during life. How can you provide for them in your passing? So we're going to talk about some of the most common estate planning tools that relate to passing on wealth or assets when you pass away. So that's kind of the good side of estate planning, right? People think this is something to think about when I die, but I like to think about it as passing on wealth and carrying on kind of your interest in the people or the things that matter to you during your lifetime. So try to go into it with that mindset. First thing to think about is what is in your estate, right? So if you're looking at estate planning and how to pass on your estate to others, how is that defined? If you are a single individual, it's quite easy. Your estate is everything that you own. If you're married, your estate is half of what you own with your spouse, and then any separate property that you may have. So separate property, even though we live in a community property state, you can have separate property in the form of gifts or inheritances that you've received as an individual. It could be assets that you owned and continue to own from before marriage. So it can be helpful to think through first, what do I actually own that's includable in my estate? And then how do I want to pass that on when I pass away? When we talk about estate planning, we also can kind of split things up into two different categories. There are probate assets, which means that assets that you haven't specifically designated a beneficiary for that are largely going to be governed by your will or your trust, or in the absence of those that are covered by state statute. But then you may also own non-probate assets, which are things that you own where you've already designated a beneficiary to receive those assets when you pass away. If everything you own is considered a non-probate asset and you've designated a beneficiary, that's a really good way to avoid probate if that's a priority to you. So non-probate assets can be bank accounts that you've designated a pay on death beneficiary. If you have retirement accounts like a 401k and IRA that you've designated a beneficiary to inherit, that's all non-probate assets. We're going to talk a little bit later about trusts or transfer on death deeds. Those are ways to also convert probate assets to non-probate assets so that they would transfer automatically at passing instead of being governed by a will or state intestacy laws. So I always get this question, or clients call and they say, I want to do everything possible to avoid probate. Is it really as horrible as it sounds? And it depends. So I get a lot of people who say, I was watching Susie Orman and she told me I need to avoid probate. I need a revocable living trust, help. Probate can be a not fun experience in some states, right? Like California, some other states, probate can be a really long, expensive process. The good news is that in Washington, we have a pretty good, efficient probate process. So I would say don't be too scared of probate if you do your planning, your estate planning well. Even if you do have to have your estate probated, it's not going to be a big burden on the loved ones that are going to handle your estate. So I would say, it's a discussion to have with your attorney and kind of in light of the assets that you have and your priorities, but probate isn't necessarily the worst thing out there, especially if you only own property in Washington state. So I'm going to go into some of the common estate planning documents that some of them help you avoid probate, some of them relate to probate, but one of the kind of best tools for a married couple that you may want to consider is a community property agreement or a community survivorship agreement. So even though we live in Washington, a community property state, a community property agreement can be a really helpful estate planning tool to simplify the transfer of assets between spouses when one spouse passes away. So it's like a contract between spouses that can help alleviate the need for any sort of probate or court involvement when the first spouse passes away. It's an agreement between spouses that says everything I own is community property. Let there be no confusion about whether something's separate or community. Everything I own at the time of my death is community property, and I'm going to give it to my spouse. So it's a document that can be recorded with the county in which you own property, provided to financial institutions, that basically says you don't have to wait for probate, just transfer everything out of one spouse's name into the surviving spouse's name. So it's a really helpful estate planning tool. It doesn't have to be long or super detailed, but it can really streamline the process when one spouse passes away. And in that scenario, right, we don't want the added stress of going to court, doing probate, making things more complicated than they need to be. Having a community property agreement doesn't completely alleviate the need for greater estate planning like a will, but it can be a really helpful tool as part of your estate planning package. Probably the most common tool in the estate planning package that people think about is a will. And anyone who's an adult of sound mind can make a will. It has to be in writing. It has to be witnessed. Your signature has to be witnessed by 2 witnesses. And it can cover what's going to happen to your property, whether that's personal property, whether that's real estate. It can cover kind of anything and everything that you want to put in writing, who it's going to go to. Another kind of thing to check if you've done a will before, especially if it's really old, check to make sure that your will is self-proving, that there's an affidavit or a declaration from the witnesses who actually signed or witnessed your will. I've run into this a couple of times where 2 witnesses witnessed the will, but they don't have what's called a self-proving will or an affidavit of the witnesses. And we have to go try to find those witnesses, 20, 30 years down the road if someone passes away. So if you currently have a will, double check that there's a sworn statement of the witnesses that outlines that they witnessed you sign the will, you were of sound mind, not under duress. That can help things go a lot more smoothly if your will ever has to be admitted to probate. Your will itself can really be whatever you want it to be. So it is something that can be geared towards your wishes, towards the people or things that you care most about. And so there's not always a one size fits all for estate planning and for your will. Most commonly though, a will is going to at least identify who you are, who your family is, kind of your immediate family, even if you don't want to gift to that family. So it helps prove that you have capacity to make a will if you can at least identify who your immediate family is. If you're making a new will, it's going to revoke your prior wills or codicils, which are amendments to wills. And then it can get into what's going to actually happen to your property. So one thing that you'll see in a lot of wills in Washington is a paragraph about personal property and probably a reference to our state statute, Title 11, Chapter 12, Section 260. So Washington is great that we have this provision that says in your will or your estate planning documents, if you reference that you may keep a separate writing gifting tangible personal property, then that will be honored as part of your will. So it's something that you can, in addition to your will, kind of designate who do you want to get certain items of tangible personal property, whether it's furniture or artwork or jewelry. My grandmother said to everyone, okay, here you have your own Post-it note color, say what you want, kind of put your Post-it note on things around the home. This is a more formal process, and it's something that you can add to and update as often as you want without having to redo your will. So that's a great tool to gift personal property. Other gifts of personal property can be specific bequests. You can give items, you can give dollar amounts, you can give pieces of real estate. Is there a specific thing that you want to go to a particular person? That can be outlined in your will. And then you should always have something that covers the remainder, right? Everything else that I own after taxes are paid and costs of administration and after my specific bequests are given, if there's anything left, here's who I want it to go to. You can have several different people, split it up by percentages or shares. Again, that's where you can really tailor your will to who do you want to share in your wealth when you pass away. Other common or kind of basic will contents is designating a personal representative or an executor who is in charge of carrying out the wishes in your will and settling your estate. You can name someone who is also a beneficiary of your estate as your personal representative, or you can name a totally independent third party. I always recommend, though, that you think through at least one or two alternates. So if the first person you designate as your personal representative passes away before you, or they're just not in a place that they can help administer your estate, that you have a couple of backups built in. You also want to check, have you appointed a personal representative who can serve with non-intervention powers? That means that you're designating this person to carry out your wishes without them having to go to court over and over again to get permission. So non-intervention powers granted in a will really helps your estate administration go smoothly, more efficient, and less expensive than a lot of court involvement. Your will does have to be signed and dated by you. So your signature needs to be witnessed by at least 2 disinterested witnesses. And as I mentioned, you also want those witnesses to sign an affidavit, kind of detailing the circumstances of the signing. So if there's ever a dispute about whether that will is authentic, we know that the witnesses were there and they've signed a sworn statement in advance. Wills can be customized depending on your particular circumstances. So if you have minor children, or maybe you care for minor grandchildren, you can designate a guardian in your will. So if there is no one left to be able to care for, have custody of those minors, have you designated someone that you would prefer to take on that role instead of the court just appointing someone? You can also have trusts built into your will. So maybe you have a child or a grandchild or a loved one that you want to gift to, but maybe they're not the best with managing their own money, or maybe they make some irresponsible decisions. You can set up a trust for their benefit so that they don't have full access to their distribution, that there's maybe some guidelines for when they receive funds or what funds can be used for their benefit. So there's a lot of ways that wills can be tailored to fit your particular needs. So I'm going to just now briefly touch on trusts. Before I do so, any big questions at this point about wills or community property agreements? Type those in the chat box and I will answer them as they come in. So trusts themselves are super varied. Trusts are an alternate estate planning tool or can be used with a will. You can specify how you want to pass on assets or manage those assets for the benefit of your designated beneficiaries. We see trusts a lot if someone wants to avoid probate completely, or they want to gift to someone who's maybe receiving needs-based benefits from the government, or they're again irresponsible, or maybe they have a lot of creditors kind of knocking on their door. A trust can be a really useful arrangement to have the benefits of an inheritance go to a designated beneficiary, but maybe they're not the ones responsible for managing those funds. I think we had a question come in. What's the difference between a personal representative and an executor? Just the name. So a personal representative is kind of the broad legal term in Washington. It's the same thing as an executor. Sometimes you do hear also the term administrator. That's a personal representative who's administering an estate when there wasn't a will or they weren't named in the will. So they all mean the same thing. They all have the same duty as far as carrying out the provisions of the estate. Another question came in about what does non-intervention mean? So non-intervention powers means that the executor or the personal representative can settle the estate without the intervention of the court. So once that personal representative is appointed by the court, They don't have to get court permission to sell real property, to make distributions, to settle the estate. Sometimes a court will not grant intervention powers if there are a lot of creditors of an estate, or maybe someone isn't entirely trustworthy that's going to be appointed. But generally, if you're appointing someone that you trust in your will to carry out your wishes, you're going to want them to be able to act with non-intervention powers, so they can act without having to go back to court and get permission for every step along the way. So it's one way that probate can be really streamlined, kind of a helpful tool if probate and court intervention is necessary. Makes things a lot easier and a lot cheaper for all the parties involved. So trusts are another tool that can be with part of your will or separate from a will. Kind of the basic structure of all trusts is that someone, the settlor, the grantor, the trustor, you'll see all of those terms, will establish a trust, and it's like an agreement or a contract, and they transfer their property into the trust. They designate a trustee, a person who is responsible for managing the property in the trust for the benefit of a beneficiary. So we hear a lot about revocable living trusts. Those are trusts where the settlor, the trustee, and the beneficiary are all the same person, right? So I can establish a trust for my benefit, as I'm the beneficiary during my lifetime, and I'm the trustee during my lifetime. And then if I pass away, right, the trustee and the beneficiary are going to change. So trust structures, though they kind of have their basic three players of the trustor, the settlor, or excuse me, the settlor, also known as the trustor, the trustee, and the beneficiary. But then we can make the trust work for your specific circumstances. I will kind of backtrack. There is a question about, is it better to have assets as joint tenants with right of survivorship or tenants in common? So that's a great question to look at. Bank account, real estate, how do you own it? If you own something, co-own with someone as joint tenants with right of survivorship, it means that whoever survives the other is the full owner. So if you own property maybe with your spouse as joint tenants with right of survivorship, like if I pass away first, my husband survives me, he now becomes the sole owner. If you own something as tenants in common, it means that you both own a share of the property. So tenants in common ownership, part of that ownership is includable in your estate. If you own as joint tenants with right of survivorship, that's a non-probate asset. It's going to transfer directly to the surviving joint owner. So you have to think through, what do you want to happen to that asset if you pass away? Do you want it to transfer to the other co-owner? Joint tenant with right of survivorship may be best for you. If you want that your ownership interest to be part of your estate, then tenants in common may be the better ownership structure. So good question. So to go back to our discussion of trusts, and particularly a revocable living trust, it's not something that I recommend for everyone, because it can be a lot of time and administrative burden and sometimes expense to set up a revocable living trust. However, it can be a really helpful tool if you really want to avoid probate. Maybe you own real estate in several different states and you want to avoid the need to probate your estate in all of those individual states. A trust can be a good structure. Maybe you have a blended family. So maybe you and your spouse both have children or family from a prior relationship, and you want to make sure that those assets are preserved for your spouse, but also for your children. So there are a lot of reasons that you may want to set up a revocable living trust. It's something I highly recommend you speak to an estate planning attorney about, because it may not be necessary for everyone. But something to look into, or if you decide to move to California, a lot of people have a revocable living trust there because probate is so horrible in that state. Other reasons you may want to have a trust, if you're providing for minors, right? You don't want a 12-year-old to inherit a large chunk of money. So you may set up like an educational trust for their benefit. We also have what's called the Uniform Transfers to Minors Act, which does allow you, aside from a trust, to instead set up a separate bank account for a minor's benefit up until age 25. You may want to set up a trust if you have beneficiaries that are incapacitated in some way, or maybe they're receiving needs-based government benefits and inheritance is going to disqualify them. There are a lot of different reasons to set up a trust. I would say it's something to speak with an experienced estate planning attorney about. Another question I get about trusts and estate planning are taxes, right? The government wants their share. So I have some clients that call up and say, I don't want the state or the federal government to get anything from estate taxes or death taxes. So it's something that may be relevant to you. The good news is there are no state or federal taxes for estates up to a certain amount. So in Washington state, your assets includable in your estate are exempt up to $2.193 million. At the federal level, that's $11.58 million. So if your individual estate falls below that threshold, you don't need to worry about estate taxes. Now, the exemption threshold can change year to year, so it's something to kind of keep an eye on if you're close. But the good news is, even if your estate is close to those thresholds, you can still gift to your spouse without any estate taxes. You can gift to charities or political organizations. Those are all exempt transfers. And if you do look at your estate, and especially with the price of real estate these days, if you own real estate, you may get at or over that threshold. That can be important to bring up with your estate planning attorney. Maybe you want to look at some tax planning strategies as part of your estate planning toolbox. Or if you're comfortable with the estate getting their, or the state or federal government getting their share, then you don't really have to do too much. So lots of things to think about when it comes to planning for death and passing on wealth. But what I think is probably the most important part of estate planning is planning for periods where you may become incapacitated or be unable to manage your own decision-making or financial affairs, whether for a short period or permanently. So even though a lot of people think of estate planning of a will, I always like to recommend that clients consider putting in place durable powers of attorney, and also think through decision-making, kind of end-of-life decisions in an advance directive, or sometimes it's called a living will. So keep in mind that a will only has effect if the maker has passed away. So if you've designated someone as your executor, they don't have any authority to act while you're alive. Instead, you need to do some lifetime planning to put in place powers of attorney. So you've designated someone that you trust to be able to stand in your shoes if you are temporarily or permanently incapacitated in some way. It can be that maybe you're going into surgery, you're going to be in the hospital for a long time recovering, and you just want to designate someone to be able to pay your bills, while you're recovering. I had a client who was recently going overseas for a long time, and so they put a power of attorney in place so that someone could manage their affairs stateside. And then you may also want to put a power of attorney in place if it's possible you suffer from dementia or Alzheimer's down the road. Maybe you're not going to be able to fully manage your own decisions and finances in the same way you are now. It's best to think ahead and put in place who you trust to step into your shoes, because if you don't and you lose capacity, the court may have to get involved to appoint a guardian on your behalf. So powers of attorney, I think, are one of those really important estate planning tools that if you don't already have in place, it's something I think you should consider putting in place now or in the near future, just to be safe. Powers of attorney can be tailored to your particular comfort level and purpose, but at their very basic level, a power of attorney creates an agency relationship. So if you are the maker, you're the principal, and you've designated an agent who can act for your benefit, step into your shoes for a particular purpose or more broadly. So you can designate an agent under a power of attorney that only acts in a limited scope. Maybe it's as part of a real estate transaction, or you can have one really broadly that someone can act on your behalf at any point in time. Powers of attorney in Washington are governed by statute. The statute does kind of specify default powers when you designate someone as your attorney in fact, or your agent under a power of attorney. But you can also tailor those powers to your particular comfort level. So good kind of starting point to look at state statute and then think about what kind of authority you feel comfortable giving someone else if you're unable to act. When you're thinking about powers of attorney, think about who do you trust to act in your best interest and to carry out your wishes if you're unable to express them at the time. You can pick a family member, a spouse, adult children. You can pick a close friend. If you don't trust any of those people or you don't have those people that you may be able to designate, there are professional fiduciary organizations that you can also designate. Usually they take a fee, right, if they have to step in and act. But that can also be a good way to maybe alleviate conflict with family members. If you're not sure who to designate over the other, maybe it makes sense to designate a professional. I also recommend that as you think through designating an agent, that you think through alternates, right? It could be that that power of attorney needs to be utilized at a time when your designated agent isn't alive or lives far away or is unable or unwilling to act. So again, it's really helpful to build into your durable power of attorney one or many alternates who can step in. Because if you don't have a power of attorney for finances, if you don't have a designated agent willing to act and you become incapacitated, then the alternative is that someone needs to initiate a guardianship for your behalf. And it's much better for you to pick who's able to step in and carry out your wishes than have a court appoint that for you. Another thing to look at, especially if you currently have powers of attorney, is to pay attention to when it becomes effective. So generally, if you are designating someone you really trust, I may recommend that you make that power of attorney effective immediately. That as soon as it's signed, that person can step in and assist you. You don't have to be incapacitated, but if you make a power of attorney effective immediately, that means that your designated agent can provide some oversight maybe on your financial accounts, can step in smoothly if needed. Otherwise, if you make your power of attorney only effective upon your disability, then there can be a little bit of a holdup in an emergency. So generally, if you have a springing power of attorney, your agent doesn't have authority to act or make decisions unless your physician, the attending physician, or your primary care physician has provided a letter or documentation about your incapacity. That's a level of protection, right? That your agent isn't going to act unless you're incapacitated. But in a lot of instances, right, if someone does need to step in and act on your behalf, particularly in an emergency, we don't want to have to wait and kind of go through the bureaucracy of having a physician provide a letter that they may be uncomfortable to provide, kind of put that opinion in writing. So it's something to think about. Do you want to make your power of attorney effective immediately? Or are you more comfortable only having someone be able to act if you have been declared incapacitated? Other things to keep in mind, a power of attorney, it does have to be in writing. You need to sign it. And your signature either needs to be notarized or done in front of two witnesses. I say that notarizing is preferable because if you have a financial power of attorney that needs to be used to buy or sell real estate, most title companies are going to require that that power of attorney be notarized. So if you have the option, that may be a good step. And as I mentioned, our state statute has kind of default powers that you can give your agent, but there's also some that have to be expressly included. You know, do you want your agent to be able to make gifts out of your assets? Do you want your agent to be able to change the beneficiary designation on your retirement accounts? Do you want your agent to be able to make transfers from your assets in order to help qualify you for government benefits? So something to discuss with your attorney or really think through what kind of authority do we want to give your designated agent. Sometimes you'll see powers of attorney that are one big document that cover both financial and healthcare decisions. Other times you may have two separate documents. I tend to do two separate documents, one for finances and one for healthcare, because who you trust to manage your finances may be a different person than who you trust to make healthcare decisions for you. A financial power of attorney can give your agent the ability to pay your bills, write checks out of your account, pay for your medical expenses, maybe make gifting out of your estate. They kind of operate in a different world than your healthcare agent under a healthcare power of attorney. So that person is the person that you've designated who can give informed consent for medical treatment if you're unable to give it yourself. If you don't have any power of attorney in place, Washington does have a statute that will specify who has authority to give informed consent on your behalf if you're incapacitated. So it kind of goes along your family tree. It's your spouse, your adult children, your parents, or your siblings, but that's only for healthcare decisions. There is not a similar statute for financial decisions. So that's why it's important to have a power of attorney, designate someone to not only manage your property, but also specify exactly who you want to be able to make healthcare decisions on your behalf. Along the same lines as a healthcare power of attorney is also an advance directive. Sometimes they're called healthcare directives or a living will. That can serve as a guide to your designated power of attorney, what your wishes are for end-of-life care and treatment. So this is one of those documents that I recommend taking your time to think through, discuss with your care providers, your primary care physician, your family, like your children, your spouse, to make sure that they really know what you want if you get to a point that you have a terminal illness or you're in a permanent kind of coma. What kind of life-sustaining treatment do you want? These documents only apply kind of at end of life, right? If I get a cold, I get the flu, I get COVID, I go into the hospital. If a physician thinks I'm going to make a full recovery, then these kind of decisions aren't really triggered. But generally, if a physician says, you're going to be this person is going to be in a permanent vegetative state, they're not coming out of this treatment is only to continue them living, kind of delay the process of them passing away. What kind of interventions do you want? Artificial hydration, artificial nutrition, artificial respiration. Do you want pain medication, even if that pain medication could speed up the process of dying? All of these decisions you can put into an advance directive. We also see that there's kind of two separate documents that you may be familiar with. One is a broad kind of healthcare directive or living will that applies if you have terminal or permanent conditions. That's something you can make on your own. It just needs to be, you sign it, have your signature notarized, or have two witnesses. You may also have a POLST form, physician's orders on life-saving treatment. It's a bright green form, front and back. It's something that you would complete with your doctor. So you sign it, your doctor signs it. In an emergency, do you want CPR? Do you want life-saving treatment? A POLST form is something you may see kind of by the front door in a nursing home or facility, or if emergency personnel may show up, where a healthcare directive is a little bit more broad. That may be part of your medical records or something you share with your healthcare agent so that they know exactly what your wishes are for end of life. We have advanced directives that are pretty basic. So our Washington state statute, the revised Code of Washington, does contain kind of a very basic advanced directive that you can kind of copy and paste and fill out and have your signature notarized or witnessed. But there are also more detailed advanced directives. So a good kind of free resource you may look into is called End of Life Washington. They have really detailed advanced directives, for end of life decisions, if you have Alzheimer's. And again, the more information you can put into a living will or an advanced directive, it's going to give your agent, your healthcare agent, directions on what they should do in certain scenarios. And it can also be helpful to share with your loved ones. If something happens to me, this is what I want. It takes the burden of making some of those end of life decisions off of their shoulders because they know what you want and they're just carrying out your wishes. So this is one of those estate planning documents that I highly recommend you have these conversations with your loved ones, with your healthcare agent, so that everyone really knows what you want and that your wishes are going to be honored. Okay, so I know that was maybe not the most uplifting topic, but before I talk about, planning to live a long time, kind of the flip side of that, just wanted to stop if there are any more questions. I don't think I see anything at this point, but if you're putting them in the chat box, please continue to do so and I'll jump in and answer those. So kind of the good news is if you live a long time, right, there's a lot of planning that can be done there. What are you going to do in your retirement? Are you going to travel? Are you going to gift to loved ones? But also, how do we plan financially for potentially the increased cost of care or living down the road? So financial planning is necessarily part of good estate planning. So when I am meeting with clients, I'm talking with them about their estate planning and what they want to put in place. I don't try to pry, but I'm going to ask questions about their finances, right? What kind of assets do you own? What do you have available to you to pay for your long-term care? And what's likely going to be left that you may pass on to your loved ones? So financial planning is a big part, kind of the full estate planning picture. So don't be offended if you meet with an attorney and they ask you questions about your assets, your health status or diagnosis, and kind of what are your future needs or goals. They may ask questions about what kind of retirement benefits do you have? What are you receiving from Social Security? They may ask, if you need increased care, do you really want to stay in your home and pay for in-home care? Are you comfortable moving somewhere like a community or assisted living community where care can be provided, maybe as things progress? How do we financially plan for what your goals are? So there's a lot to take into consideration. So if you haven't kind of taken a look at your assets that are available to you, estate planning is a really good time to start looking at everything you own. What are your goals? And how are you going to meet your potential future needs? Clients, I ask them questions about how do you plan to pay for your care? Do you have long-term care insurance that if you do need increased medical care that Medicare or your regular health insurance isn't going to cover? Do you have this type of benefit? Do you plan to have Medicaid or the state government assistance cover your expenses? So we get a lot of questions about Medicaid planning as part of estate planning. Medicaid is separate from medical or from Medicare. Medicaid will cover long-term care expenses, but the state and the federal government look at, do you have the medical need? Do you need assistance with activities of daily living? But do you also financially qualify? And basically your assets have to be very, very reduced in order to qualify for Medicaid. So I have some clients that say, I transferred everything I own to my kids, so now I can qualify for Medicaid. Medicaid has a 5-year look back period. So transferring assets, really close to a period of time where you may need Medicaid coverage can actually disqualify you. So planning to pay for care is a big part of the estate planning discussion. One question, what's an estimated cost to get a will, power of attorney, advance directives, and community property agreement? Every law firm is going to be different. Our firm, we charge by our time, right? So where clients have really thought through these decisions in advance, that can really streamline the process for us. So a married couple, kind of all of those estate planning documents can be anywhere around $1,000 to $1,500. If they have a really complex estate or estate tax considerations, it can be higher. I would say that's kind of a general ballpark. You can go online, you can find attorneys that do flat fee. That may be what works best for you. I always just recommend that you take your time and make sure the plan is tailored to you. And even though there are a lot of law firms that do estate planning, not everyone takes into consideration things like Medicaid planning, tax avoidance, kind of planning for all the, unfortunately, worst case scenarios down the road. So we're one option. I could tell you that you'll probably find estate planning less expensive, more expensive. The goal is just to find someone that meets your particular needs and is easy to work with. I was also going to mention in the time of COVID, some tips for estate planning. So if you can't tell, I'm working from home. I've been working from home for about 7 months. Half of our office is in the office. Half of us are working from home. We are doing a lot of our initial estate planning appointments over the phone or with the use of Zoom to try to reduce any sort of in-person exposure. When it comes to signing and finalizing documents, we are meeting with clients in our office and kind of taking every precaution possible to do that. But I'm also being very flexible. Last week, I met with some clients to sign their final documents. It was a beautiful day. We met at a park. They had a witness that was a neighbor of theirs that they had been in contact with already, and we did their signing outside. So these days, I think a lot of attorneys are trying to be flexible, minimize face-to-face contact, but still have that relationship of seeing the other person like on a Zoom call and eventually meeting face-to-face to put final documents in place. So with everything I've just said, hopefully I haven't totally overwhelmed you. Maybe I've solidified the planning you've already done, but I just want to leave you with a couple of tips of things that you can do now, especially if you're still kind of quarantined at home, you're going stir crazy. Here's some planning to think about that you can get started on now. If you currently have estate planning documents, now is a good time to pull them out from the file folder or the safe or wherever they may be. Take a look at them and make sure that they still reflect your priorities and your wishes. I recommend you pull out your estate planning documents every few years. Anytime there's a big life change, someone gets married, someone has kids, you retire, you're moving, make sure that it still fits your needs and your wishes. Good estate planning documents will have alternate arrangements in place. So if your designated, personal representative doesn't want to serve, do you have alternates? If a beneficiary that you've designated passes away before you, what happens to their share? So taking a look at what you already have, making sure it makes sense to you. If you don't have any of these documents, now's a good time to think about putting them in place. Good question. So can you give assets away to reduce state estate tax? Yes. So that can be part of your estate planning is lifetime giving, right? You don't have to wait till you pass away to gift to the people or the organizations that you care about. So you may have a potentially taxable estate. Maybe you make gifts during your lifetime to help reduce that taxable estate. You can gift to charities during your lifetime or during death. Those are not going to count against you as far as taxes. So that can be part of that financial planning aspect I mentioned, taking a look at the big picture. If you do have a taxable estate, let's look at a plan to carry out your wishes and potentially reduce estate taxes down the road. Another thing that you can do now, even if you're not physically with your family or going to in-person kind of doctor appointments, it's a good time to have some of these conversations with loved ones and your primary care physician. What are your wishes if something happens to you? Again, letting them know your wishes in advance makes things a lot easier for them to be able to carry them out and can help reduce kind of the emotional burden of making some of these decisions. You can talk to your physician. A lot of times these decisions about, do I want artificial respiration or hydration? That's something to talk to your doctor about. What are the implications of receiving these types of treatments? So again, not maybe the most uplifting conversations to have, but it's really helpful to reduce conflict down the road, reduce confusion if you start having these conversations now with the people who may have to step in and make decisions down the road. Another thing that's really important, especially if you've already done your estate planning, let people know where to find these documents in an emergency. So if you keep your estate planning documents in your office, in a particular folder, who have you designated as your power of attorney or your personal representative? Let them know if something happens to me, here's where to go find these documents. I have some people that say, oh, I put my will in my safe deposit box. Well, if you pass away, who's going to be able to access that safe deposit box? Sometimes we have to go to court, get a court order just to open it. So think about where you're keeping your important documents. Is it a place that's safe, but also that the people who may need to use those documents, do they know where to find it? I also recommend, this is a good time to kind of put together a cheat sheet. Look at your assets. Do you have a CPA or an accountant that you always use for taxes? Maybe include their information with your estate planning documents so that if your personal representative, your power of attorney needs to jump in and manage your finances, who has the information, right? Where do you bank? Where do you keep your important documents? Kind of putting all that information in one place for your trusted fiduciaries, that can be really important. Let's see, a couple more questions. Yeah, good comment, giving a copy to your kids, right? Letting your family members know, here's what I put in place. So some clients like to share copies of everything with their loved ones so that everyone's on the same page. Some people are more private. Again, I just highly recommend you have these conversations with the people that you trust and you've designated so that they know what's expected of them, where to go find these important documents if they ever need to use them. And then if you've done your estate planning, kind of put the package together, you've gone through your checklist, you feel good, tuck it away, enjoy your life. Every few years or big life events, pull it out again just to make sure it still fits your wishes and priorities. But don't worry about it, right? I know that doing estate planning can kind of loom over you, but my goal with my clients is we do it, we put your wishes in place, and then you tuck it away and it doesn't have to be a worry at this point. So that's kind of my advice for what to do now as you're maybe sitting at home and the weather's changing. But keep in mind, we only kind of skimmed the surface. So if you do have additional questions, feel free to reach out to me, and feel free to kind of do your own research on a lot of these topics and, potentially connect with an attorney that you think is going to be a good fit. Maybe it's just overlooking your current estate planning documents, make sure there are no issues. Maybe you want to start from scratch. But start having those conversations and thinking about these issues.
Thank you, Elizabeth. We greatly appreciate your time today and the information you provided in the Power of Planning webinar. I will email for all the attendees. We will email a copy of these slides to all of you, along with Elizabeth's contact information. We'll also include a survey sheet we'd like you to fill out and tell us about your experience in today's event. Thank you, everyone, for attending.